I'm waiting for another 5 minutes until others join. So just 5 minutes because, still participants are logging. So just wait for another couple of minutes. Okay, ladies and gentlemen, in my previous presentation, I discussed I started to discuss disciplinary procedure which will be applied for the private sector workers. If I'm not mistaken, we have discussed up to slide number 17, types of misconduct, right? Am I correct? Anybody who was attending the previous session? Ladies and gentlemen, do you remember where we stopped?
In this slide.
Yeah, we have to start from, the next slide. Am I correct?
Yes, sir.
Okay, right. So remember that, every organization has their own disciplinary procedure. Okay, but in labor law, there is no precise or specific disciplinary procedure stipulated in labor laws. However, we have plethora of labor court cases, whether that kind of actions are misconduct or not. Misconduct leads to take disciplinary action. If you behave unnecessarily or anything misconduct, right, the organization can take disciplinary action. So therefore, you have to remember that if you are a worker, right, what are the misconduct and that you should not do, and if you did so, if you do so, what are the punishments that you will be imposed? Okay, I told you directly there are no direct provisions in labor law with regard to disciplinary matters. However, if you look at the Sopan-Office Employees Act, already you have studied and you have learned. You remember that under authorized deduction. Under authorized deduction, if you remember, there is one, element, what is that? Up to 5% of fine from the salary can be imposed on the employee by the employer in respect of any of the following acts or omission. පහත දැක්වෙන ක්‍රියාකාරකම් වලින් එකක් හෝ ඒවා සඳහා සිදු කළහොත් salary එකෙන් 5% දඩයක් හැටියට අය කරගන්න පුළුවන්. This is one of the authorized deduction. Right? So under this, look, absent from the work without reasonable excuse. This is actually a misconduct. Word misconduct is not precisely used in the Shop and Office Employees Act, but it says absence from the work without reasonable excuse, then your employer can impose 5% of your salary as a fine, right, for your for that action. Therefore, even though the word misconduct is not precisely used, this comes under the definition of misconduct. And the late attendance, right? We noted around 25 misconducts, types of misconducts. So these are coming under those areas, causing damage to or causing the loss of goods or articles belonging to the employer. Such damage or loss losing directly attributed to the negligence, willfulness or default of the employee, slacking or negligence at work, sleeping on duty, willful failure. So these are, so what does it mean? Indirectly, the labor legislation, Shop and Office Employees Act, recognizes the punishment for types of misconduct. Okay? Do you understand? Do you understand?
Yes, sir.
Yes, sir.
Right. And then look at, again, these are, I don't need to, this list is same. The list is the same as Wages Board's ordinance. Wages Board's ordinance එකෙත් මේ ටිකම තියෙනවා. එතකොට Wages Board's ordinance එකයි Shop and Office Act එකයි දෙකම misconduct කියන වචනේ පාවිච්චි නොකරට එවැනි එක ව්‍යංගයෙන් කියනවා එවැනි කටයුතු සඳහා දඩුවම් කරන්න පුළුවන් කියලා. Right? What, these two legislations, Shop and Office Employees Act and the Wages Board's ordinance as well, recognizes that the employer has right to impose fine or punish by way of disciplinary action against the misconduct done by the workers. Okay? Right. And then look at the intimidating and misconduct. Intimidating. Here, then you have to look at the list. Look, number 1, absent and late attendance, negligence, insubordination, abuse, assault, false allegation against supervisor, drunkenness, disloyalty. Most of these, are covered by the Shop and Office Act and the Wages Board's ordinance under the authorized deduction, right? It has recognized. And then, okay, moving to my, next slide. So intimidating and misconduct. Where is the intimidating? Look, right? It is also was there, but if I have made a mistake, it should also be included. Yes, intimidation, number 23. Okay. What it says, this is the court case, Supreme Court decision. What it says, when any person reads the said memorandum marked as මේවා ඔක්කොම memorandum කියන මතක තියාගන්න ඕනේ නැහැ. The wording of expression explicitly demonstrate that the applicant was right? Uh, carrying favor with the CEO, right? Jack Courier, right? This is a court case, but we have to look at it was something which any employee should never have done, because the employment of the management level high officers such as chief executive officers is up to the right parent company. Making කියන්නේ CEO intimidate කළා, right? ඒක වැරදි, ඒක misconduct එකක් කියලා කියනවා. So you have to take note this one, right? Which one? Misconduct and Sopan Office Employees Act. This one. Could you please take your note? Medical ලියා ගන්න ඕනේ. හරි. නඩු තීන්දුව ලියන්නේ නැහැ අපි. Okay? Do you want me to read, or could you please take your note? I have already described. එහෙනම් ලියා ගන්නවද?
Okay, sir.
Okay, sir. Okay, sir. Sir, can you make it large, sir?
Oh, sure. Just 1 second. When you finish, let me know. Finish?
No, sir. Still IT.
What about now?
Complete, sir.
Finished, sir.
Okay, then after that, so write as this, because there are plenty, right, up to O. The above list is the same as the above list is the above list is same under the wages boards ordinance, under the wages boards ordinance as well. So I'm just explaining court decisions. I'm not what do you call this, giving notes, but explaining. I will explain the court decisions. This is something, another court decision, Ceylon Workers Congress CWC versus Janata Estate Development Board, right? The suspension from work did not amount to constructive termination. In the face of the clear manifestation of the workman's intention not to vacate the line room, there was no purpose in holding a domestic inquiry. මේකේ කිව්වේ දැන් කෙනෙක් මේ වතුයායක කෙනෙක් එකෙන් සුපිරින්ටන් කෙනෙක් මොකක් හරි හේතුවකට මොකද කළේ මේ එයාට වැකේට් ඒ කියන්නේ එයාව සස්පෙන්ඩ් කරා. සස්පෙන්ඩ් කරා කියලා කියන්නේ සේවය අවසන් වුණා කියන එක නෙමෙයි. ඊට පස්සේ සස්පෙන්ඩ් කරලාම so he has to vacate his quarters. But unfortunately, that person did not vacate the quarters. Based on that, the company, Janata Estate Development Board, terminated the employment of that person, not because of the previous case, because of the something he has done. So therefore suspension, he was suspended and he was asked to vacate the quarters, but he did not. Then his complaint was, worker complaint was, he was dismissed without having inquiry, right? Holding domestic inquiry. That was the argument of the worker. And then court said that in the pace of the clear manifestation of the workman's intention not to vacate the line rule, there was no purpose in holding a domestic inquiry. Domestic inquiry එකත් තිය ඉන්න ඕන කියලා එකක් නෑ. Right? එයා suspend කරා නම් quarters එක vacate කරන්න ඕන. Vacate කරේ නෑ. එතකොට suspend කරේ වෙන කාරණයකට. ඒකට inquiry එකක් තියන්න ඕන. නමුත් ඊට පස්සේ suspension එකත් එක්කම එයාව vacate කරන්න කිව්වහම quarters එක ඒක නොකළා. ඒක වරදක්. ඒ නිසා කෙලිම dismiss කරා. terminate කරා. ඊට පස්සේ මේක ඉහළ අධිකරණ දක්වා ගියා වුණත් අන්තිමට කිව්වා නෑ එහෙම holding domestic inquiry තිය ඉන්න ඕන කමක් නෑ කියලා. හරි? ඒවා තේරුම් ගන්න. So ඒකෙම කියනවා I'm of the view that the termination was justifiable. Terminate කරා. Termination එක දැන් මතක තියාගන්න මෙන්න මේ දේ. Misconduct එකක්. Which leads to disciplinary action. Which leads to take disciplinary action. Disciplinary action වල තියෙන බරපතලම එක මොකද්ද? The major punishment is the termination. Remember that any types of misconduct, if you did any types of this, the misconduct, the employer has right to dismiss, right to dismiss in the sense, the terminate on the spot. Employer can terminate. However, when employer goes to LT labor tribunal, right, with labor tribunal, the burden of proof goes to the employer. Employer has to prove that he has done misconduct. So therefore, the employer has to prove that the termination is justifiable. In this case, court decided that the termination is justifiable. Right? ඒක මෙහෙමත් කියනවා. The management will not be able to maintain discipline in the estate if the workman refused to vacate vacate as the management failed to provide a cattle shed and equivalent to land. ඒ කතාවේ කියන්නේ vacate කරන්න ඕන කියන එක කියන්නේ. Right. And not having the same thing actually, the same another Talawakale plantation. That this also a same case, same scenario. Okay, now I'm raising a question. Can an employee work for another employer while working under an employer? What do you think? That is also comes under the misconduct. Can you work for another employer if you are an independent contractor? Yes, you can. But if you are not independent worker, working for a company, can you work for another employer as well? What do you think? Let me ask. Dinesh, what do you think?
If he working with a contractor, it is not possible.
Contract in the sense, if you are an independent contractor, you are not a worker, no. First of all, you have to understand who is worker and who is independent contractor. At the beginning, we discussed these things. Table ගහලා දෙපැත්තට බෙදලා අපි ඉගෙනුවා මේ. Contract of employment should not be in writing, right? It may be oral, implicit, explicit, whatever it is. If you are a worker, then you are not supposed to work for another employer. So this is real case. A person joined ABC company in 1999, right? Working night shift. He had to work at night. In 2009, after 11 years or 10 years later, he worked for XYZ company in the daytime. It was revealed and dismissed him for violation of the contract of employment in 2010. Meya reason එක උනේ, he has violated the contract of employment while working, for a company ABC. He has worked for another company in daytime, XYZ company as well. So ABC company revealed that this man is working for another company. So it is kind of a, the violation of the contract of employment. So his service was terminated. He was terminated. And he complained to the LT then. Labeled that is the procedure now. And LT awarded compensation. And then the company went to, ABC company went to Provincial High Court. That is the procedure now. Provincial High Court also affirmed the LT award. Then again, company can go for a leave to appeal to the Supreme Court. And company went to ABC, company went to Supreme Court. Then what has happened? What do you think? Right. This is also, the case is this. I used, in this diagram, ABC and XYZ, but the case is this. RHSC Soisa versus R City Central Hospital PLC. Make a real case. Supreme Court appeal case. Decided on 2017. In this case, the Supreme Court held that an employee cannot violate the contract of employment, which is a primary document. Therefore, the Supreme Court set aside the judgment of the Provincial High Court and the award of the Labour Tribunal. ඒක වැරදි. Labour Tribunal එකේ award එකක් වැරදි. ඒක හරි කියලා දීපු Supreme appeal court, Provincial High Court decision නැත්නම් Provincial High Court එක appeal court එක හැටියටත් වැඩ කරනවානේ Provincial Appeal Court. වැරදි කියලා Supreme Court එක තීන්දුව දුන්නා. I think this is important. So could you please take your note? This diagram, first this diagram. Is it visible or do you make me to, make it larger? Is it visible?
Yes, sir, visible.
Okay, then take your the diagram as it is. Once you finish, let me know. දැන් මේ වගේ ඒවා මෙහෙම බෑ කියලා කොහෙවත් නැහනේ. පොතක නීති පොතක නැහැ. ඒවා තීරණය වෙලා තියෙන්නේ මොනවෙන්ද? මෙහෙම කරාම employer takes action. The major action or major punishment is the termination. Then they go for LT, legal cases. Then the court decides, court system in Sri Lanka decides whether it is justifiable, termination is justifiable or not. I observed today is very few participants. Yes, it is not there. This subject, this topic is not there in the labor law, I mean the industrial law in your syllabus. But this topic is equally important as other topics under the industrial law. ඉවරද?
Yes, sir.
Yes, sir.
Now this one. This is the decision. Here, the question mark, Supreme Court. What was the decision of the Supreme Court? This is the decision. I put ABC, XYZ, but this is the real case. The Soisa worked for Asiri Central Hospital at night, and the daytime he worked for another one. It was revealed, and then the employment of Soisa was terminated by Asiri Central Hospital, and he went to LT. Hello? Okay. Take your note, this one as well. I hope it is visible. ඉවරද?
Not yet, sir.
What about now?
Okay, sir.
Right. So again, the same, similar case, right? Kotagala Plantations was Ceylon Planters Society. So can an employee work for another employer while working? Similar case. In the instant case, it is noted that acts of misconduct previously committed by the workman include unsatisfactory attendance, purchase of deals in an unauthorized manner for personal use, leaving the estate without obtaining leave, failure to report for duty once the paid period of leave expires, acting in breach of the terms and conditions of employment, and managing a tea plantation that does not belong to the applicant or appellant or respondent, etc. So finally, this goes, the decision was the same as in the previous case. So look, right, unsatisfactory attendance, purchase of unauthorized leave, leaving the estate without obtaining leave. These are misconduct. So therefore, dismiss or termination of employment is justifiable. And then next one, use of, right, obscene language, asabya basa, and misconduct. Asabya වචන පාවිච්චි කිරීම misconduct. මේකටත් අපිට තියෙනවා court decision එකක්. We have Health and Company Ceylon Limited versus කාර්යවසම්. නඩු තීන්දුවේ කියනවා. The use of, right, obscene language, actually obscene language, obscene language, when addressing the employer's representative, a contemptuous disregard for any form of discipline, coupled with threat of violence, should not be condoned in the name of industrial peace. Such a course can only lead to an industrial chaos. ඒ කියන්නේ මේ විදියට අසභ්‍ය වචන වලින් කතා කරලා හාම්පුතාටවත් හාම්පුතාගේ නියෝජිතයෙකුටවත් බනින්න එහෙම බෑ. එතකොට ඩිසිප්ලින් එක ආරක්ෂා කරන්න බෑ. ඒක කාර්මික සාමය ආරක්ෂා කරන්න නෙමෙයි, කාර්මික සම්බන්ධතාවය බිඳවට්ටන්න හේතු වෙනවා. right? So අපි හැමෝම හැම එකක්ම, so you don't need to take note with regard to each and every, the court case. Right. ඒක නිසා අසභ්‍ය වචන ඒවා obscene language එක. ඒ කියන්නේ අනවශ්‍ය විදියට ඒ කතා කිරීම හොඳ නැහැ. ඒක ඉන්ඩස්ට්‍රියල් පීස් එක ඇති කරනව වෙනුවට ඉන්ඩස්ට්‍රියල් කැවෝස්. ඒ කියන්නේ ඉන්ඩස්ට්‍රියල් පීස් එක අවුල් කරලා දානවා, වියවුල් කරලා දානවා. Right. Use of language use of abusive language and misconduct. Again, we have court decision. Lanka Synthetic Fiber Company Limited versus Pereira. A Supreme Court decision. The use of abusive language towards the superior is a misconduct. ඒ නිසා වැඩ කරන තැනකදී තමන්ගේ superiors ලට අසභ්‍ය අනවශ්‍ය විදියට ඒ කියන්නේ abusive language භාවිතා කරන්න එපා භාෂා. ඒක එහෙම වුණාම ඔබව the employer can terminate you. So then when you go to labor tribunal also look at the previous the court decisions. Based by looking at the court decisions, they also may dismiss your application. Right. So because we have Supreme Court case decided by the Supreme Court, but it says the use of abusive language towards the superior is a misconduct because it creates such a situation in which it becomes impossible to maintain proper discipline in an establishment. Whatever may be the reason of the use of abusive word, it is a recognized misconduct. It is a recognized misconduct. And unlike use of defamatory words, it has no exception. It means that the use of abusive language will be misconduct irrespective of the circumstances in which it has been uttered. මොන අවස්ථාවක වුණත් මොන තරම් කේන්තියක් මොනවා තිබුණා වුණත් abusive language එක පාවිච්චි කරොත් right ඒක මොනවාද අපි කියනවා it is a misconduct. What is that? It is a misconduct. ඒ කියන්නේ අපි කියන්නේ මොනවාද එකට මොකද්ද කියන්නේ abusive අපයදුම් ඒ කියන්නේ ඒක appropriate language එකක් අපයදුම් භාෂාව. ඒ කියන්නේ හොඳ භාෂාවක් නෙමෙයි අපස් මොනවාද අපයදුම් තව සරල කරලා කිව්වොත් it's a kind of අසභ්‍ය කියන එක තමයි කියන්න තියෙන්නේ. Right. Okay. So what do you think? Do you want to take note in this regard? Use of abusive language, this court decision. Do you want to take note? What do you think? If you used to do so, or otherwise, I have explained. Is it enough?
Enough, sir.
Okay. Right. Absent and late attendance. Right. Dismissal of an employee for absent. මේ ඔක්කොම කේස් තියෙන්නේ මේ misconduct කරපුවා terminate කරපු cases. Terminate කරපුවා. Dismissal of an employee for absent in excess of his leave entitlement over several years was held to be justified. Absent late attendance දිගින් දිගටම ආවහම ඔබව සේවයෙන් අයින් කරුවොත් නඩු තීන්දුවක් තියෙනවා. right? Court of Appeal ඒක justify කරන්න පුළුවන් කියලා. Go slow and misconduct. Go slow, හෙමින් වැඩ කිරීම. The termination was on disciplinary ground as they were engaged in a go slow campaign, right? Despite having given individual undertakings to bring the output to normal production level. Go slow කියලා කියන්නේ ඕගොල්ලෝ හිතාමතාම හිමින් වැඩ කරනවා. output level එක ගේන්නේ නැහැ. මේ නඩු තීන්දුව තියෙනවා international cosmetic Applicators Private Limited versus Arya Lata and others came at 1995. I need to tell you, there is 2006 court case as well. In 2006, the Supreme Court decided that the Varaya Sevuk, the harbor workers went on a strike, and then exporters were affected. They were struggling to send their export on time. Raw material was not on time, not available on time. And therefore, their production line was, every production was affected. So then, Joint Apparel Association Forum, JAF, went to Supreme Court, right? Their argument was, due to this strike, go slow actually, not a strike, go slow. Right? Their fundamental, exporters' fundamental right has been violated by this go slow action. After, having heard this case, Supreme Court decided that go slow is not a strike, it is a misconduct. It is a misconduct. So if it is misconduct, employer can directly terminate. Summarily termination. Right? The word used is summarily termination. On the spot. Right. Absent and late attendance also the same. Again, we have another case for absent and late attendance. And negligence and incompetence. Negligence is a ground to be ground to the dismissal. ඔබ නොසලකා හැරීම් කරොත් ඒක පාර කපනවා මොනවා කරන්නද සේවය අවසන් කරන්න. In Liver Brother එක්සත් කම්කරු සමිතිය versus Liver Brother company, the court held that dismissal of an employee on the ground that he while in charge of the machinery that was in operation was found asleep at his place of work, and that such machinery, if not supervised, could cause damage to property and other employees could be justified. මොකද කළේ මේ මනුස්සයා නිදාගෙන machine operator supervisor නිදාගත්තාම machine වල මොන හරි ප්‍රශ්නයක් වුණොත් property damage වෙනවා අනිත් මිනිස්සුන්ගේ ජීවිත වලට හානි. ඒ නිසා මොකද කරේ මෙයා සේවයෙන් ඉවත්, he was terminated, and it went to the up to court, LT, and then higher courts. Finally, the court decided that, higher court decided that termination is justifiable. We have same case in the Sri Lanka Central Transport Board versus Jayasundara as well. So therefore, negligence, we have Supreme Court case as well, Supreme Court appeal. Hemasiri Gomis versus Kalaniya Cooperative Society Limited. Make it negligence nang elawanna puluwan rassawe. Incompetence. In some decided cases, the superior courts has led that in certain circumstances, an employee could be dismissed on the ground of incompetence. But it may be violation of Section 2 of the Termination Act of Sri Lanka. According to the Section 2 of the Section 1 of the Termination of Employment of Workmen Act, number 45 of 1971, without prior written consent of the worker or without prior written approval or sanction from the Commissioner General of Labour, the employer is not supposed to terminate any worker. Okay. So incompetency cannot be equalized with the misconduct. So, termination of service of a workman on the ground of physical incompetence. Physical. මේ නඩු තීන්දුවේ කියන අවසානයේදී Court of Appeal. Thus, physical incompetency is not considered as a misconduct. ඔබට ශාරීරිකව අපහසුතාවයක් තිබුණයි කියලා ඒක misconduct එකක් හැටියට සලකලා ඔබ සේවයෙන් අයින් කරන්න බෑ. That is what it says. Okay? If you want to take some notes, please let me know. Otherwise, I'm just explaining the court decisions. Because this is a lengthy presentation. More than 100 slides. And here also, termination of the service of a workman on the ground of inefficiency or incompetence. St. Anthony's Hardware, this is a very famous case. St. Anthony's Hardware Stores Limited, Ranjit Kumar and others, the court held that termination of the service of a workman on the ground of inefficiency or incompetency is not termination by reason of punishment imposed by way of disciplinary action within the meaning of Section 2 of the Termination of Employment of Workmen Act number 45 of 1971. Accordingly, the Commissioner of Labour has jurisdiction to inquire into and make order under this statute in such a case. So what it says? Termination based on inefficient, on the ground of inefficiency or incompetency is not justifiable. Is not justifiable. Insubordination, සහයෝගය නොදීම. This is misconduct, right? In the Democratic Worker Congress versus the Superintendent, මේක නඩු තීන්දුවක කියනවා, it is held that a threat to assault a superior officer is gross insubordination, warranting dismissal. එහෙම කරාම එනිසා superiorලත් එක්ක ගැටෙන්න යන්න එපා. In the Ceylon Mercantile Union versus Golden Prasa, the court held that the dismissal of a peon for rudeness towards a clerk was held to be justified. Rudeness. වීම ඒකත් dismiss කරන්න හේතු වෙන්න පුළුවන්. Again, we have the same cases in subordination. I'm not explaining one by one. Holding an unlawful meeting in the workplace. Holding an unlawful meeting in the workplace. Let's see what is this case, whether it is a misconduct or not. The service of the employee, the secretary of the first respondent union, were terminated by the employer. For what? Because he held a meeting of workers on the employer's premises without the employer's permission, contrary to a collective agreement. Collective agreement එකේ තියෙනවා. ඒවා අවසරයක් නැතුව ඒව තියන්න බෑ කියලා. The said termination of service was included in the terms of reference in an arbitration under Section 4.1 of the Industrial Dispute Act. The arbitrator held that the employee acted co-secretary of the union and that the employee's conduct was mainly a representative capacity, which was a mitigatory factor. Hence, thus, the arbitrator decided that the termination was unreasonable. Termination එක මොකද වුනේ? අහන්නේ නැතුව හාම්පුතාගෙන් අවසර ගන්නේ නැතුව මීටින් එකක් තිබ්බ යූනියන් එක. ඒක නිසා මොකද කරේ? එයාගේ සර්විස් එක ඩිස්මිස් කරා. ඊට පස්සේ එයා ගියා, the worker went to the labor department and inquiry was held. Finally, it was referred for an arbitration. Arbitrator awarded that the termination was unreasonable. And then the company went to Court of Appeal. Court of Appeal affirmed the decision, award of the arbitrator. And then again, the company, Walanka Limited, went to Supreme Court. Supreme Court justified the termination. Supreme Court justified the termination. LT award was just termination is unjustified. It was affirmed by the Court of Appeal as well. And then the company went to, against the decision, went to the Supreme Court. That is the highest court in Sri Lanka. Supreme Court said that the termination is justifiable. Unlawful meeting, you can't have unlawful meeting in the work premises because that place belongs to the employer. So without getting the permission of the employer, so you can't have your own union meeting at the workplaces while working. It is misconduct. Okay? Do you understand? Nobody is responding. Okay, whatever. And the abuse. Bava and Company Limited versus Ceylon Mercantile. Sorry, this spelling mistake. Ceylon Manure Industries, Ceylon Mercantile Industries Workers Union. Supreme Court. Decision එකක්, unreported එකක්. So what it says, most of the time abuse, right? කියන්නේ අපයදුම් abuse කරනවා කියන එක මම කලිමුත් මේක කිව්වකට මතක ඇති. Abuse of superior officers of the institution justifies the termination. නිසා ඒක කරන්න එපා. Abuse again, same thing. And assault. Assault in the superior officer, even outside the premises, out of working hours, justifies termination. So look, right? Assault. If you assault your superior, right? Even at outside the workplace, outside the working hours, out of the working hours. And then in such cases, your employment can be terminated. It has been justified by the court system in Sri Lanka. Ladies and gentlemen, do you understand? Is it clear to you what I say?
Yes, sir. Yeah.
Right. And the false allegation against superior. I'm giving what I'm explaining. I'm giving court decisions for each and every misconduct. Okay, right. False allegation against superior. This is also a misconduct. So termination is justifiable. Drunkenness, yes, it is misconduct. We have court case, right? In Sanmugam and others versus Alaric ice cream. What it says? This is somewhat critical. It is said that all the time an act of drunkenness does not merit termination. The act must be proved by the employer. So if the employer dismiss a worker because of his drunkenness, the employer has to prove it. So therefore, again, there was no proof of drunkenness and the employer did not give an opportunity for the workman to explain and neither accept the explanation offered by the workman. The dismissal was arbitrary. එනිසා මේ වගේ අවස්ථාවක වහාම බීලා ඉඳලා අහුනොත් කරන්න ඕනේ just complain to the police and take him to a doctor and get a report whether he has taken liquor or not. Otherwise, without undertaking that proper mechanism, don't dismiss, don't terminate, because the employer or you can't prove at the court. Loss of confidence. This is also misconduct. We have a number of court cases. Dishonesty, loss of confidence. Also, we have Supreme Court decisions, People's Bank versus Lanka Banku Sevaka Sangami. So this is also dishonesty and loss of confidence, especially the bank people, accountant working in a bank, right? They can't lose the confidence. They must, work properly because they are handling the public money. So they has to be, right, honest, and they must have the confidence. So if you lost that, yes, termination is justifiable. It is not, I'm not saying it, Supreme Court has said, have decided. And then dishonesty and loyalty, these are disobedience, also misconduct, disobedience, and refusal to accept transfer. Transfer කරන්න පුළුවන් කියලා පත්වීම් ලිපියේ තිබුණොත් එහෙම transfer කරාම ඒක පිළිගත්තේ නැත්තම්, if you do not accept it, your employment can be terminated. It is justifiable. Court of Appeal case, Sri Lanka Nidas Sevaka Sangamaya and Ceylon Leather Product Corporation. And refusal to accept transfer also, we have another court case. So don't refuse the transfer. Then what will happen is, the employer will dismiss you. And sexual harassment at workplace. We don't have, proper, we have some, views of the textbook writers, S.R.D. Silva, law of dismissal, and but this is the opinion of the textbook writers. We don't have any court decisions with regard to sexual harassment at workplaces. Strike and vacation of post. Strike and vacation of post. The Industrial Dispute Act, ladies and gentlemen, recognizes a basic right of workmen to commence and to participate in a strike to express their grievance and to win their demand, subject to the restrictions and prohibition that are specifically laid out. It is very clear. As per the provisions of the Industrial Dispute Act, the worker can enjoy the trade union right. He or she can participate in strikes to express their grievances, but within the legal framework. The employer could not validly issue an ultimatum to workmen on a lawful strike, requiring them to report to work before a specified date, or in the alternative be considered as having ceased to be employees, or as having abandoned their employment. What it says, ladies and gentlemen, for example, if you participate in a strike, right? If you are, the group of people, group of workers undertake strike. In such a situation, the employer cannot issue a letter of, issue a vacation of post, letter of, the vacation of post. And the employer cannot force you to report to work, otherwise you will be dismissed. So that is not possible. So employer, because if you are undertaking participating in a lawful strike, so employer cannot post you. Then it becomes unfair labor practices, as I explained to you, right, in under the Industrial Dispute Act. So therefore, if you are undertaking lawful strike and participating, your employer cannot terminate you, cannot force you to return to work, and otherwise you will be dismissed. No, it is not possible. It is illegal. Okay, it is illegal. Right. Vacation of post. In this case, ladies and gentlemen, in order to vacate the post, two elements must be fulfilled. Two elements must be fulfilled. One is the physical element. Physically, you is not there at the workplace. Second is your mental element. You are purposely not attending, not reporting to work, because you have intention to vacate the post. However, for example, right? Let me give this classic example. Though an internal inquiry into the matter issued in the termination of the respondent services on 31st October 19, the respondent used successfully appealed to. This was, the plight attendance, right? Plight to steward. Case Supreme went up to Supreme Court. Jacotting versus Air Lanka Limited. Sri Lankan Airline, Air Lanka Limited. Make case the lady she was because issued a letter saying that he has vacated the post, right? And then however, after having inquiry, again she was re-employed, but demotion. She was demoted under the condition of demotion of the respondent to the post of flight steward, grade forward, without charge any, without change salary. Salary එක වෙනස් කරන්න නැතුව demotivate කරනවා. ඊට පස්සේ මොකද කරේ? A restriction of the respondent's duties, including a prohibition on his involvement in conducting duty-free sales. Duty-free එක පැත්තේ යට යන්න බෑ කියලා නියම කළා. Number 3, a mandatory unpaid leave by the respondent for the period from 31st to October 1926. කියන මේ period එකේ මෙයා ඇත්තටම vacate කරලා හිටියයි කියන මේ period එකේ unpaid leave හැටියට සැලකුවා. So what happened was he didn't agree for these conditions. For these conditions. So then she was dismissed because he didn't agree and then dismissed. Then she went to the Court of Appeal, LT, and then the Court of Appeal, and finally it went up to Supreme Court. So Supreme Court, the LT, what has happened was Labor Tribunal made his order dismissing the application of the respondent. The learned president held that as per the case of Nelson, the application එක මොකද කරේ dismiss කරා. ඊට පස්සේ මේ lady මොකද කරේ? Again she went to Court of Appeal. Right? Court of Appeal also decided that the LT award is LT decision is correct. But finally, she went to Supreme Court. The Supreme Court decided that so misconduct committed outside the workplace, such as Supreme Court. If an employee commit misconduct, the employee is entitled to take disciplinary action against the workman and impose a proportionate punishment. A refusal of a document revealed that the applicant had committed similar misconduct on 34 previous occasions. Therefore, the employer was justified in imposing punishment on the respondent. මේ අවස්ථාව කණනාවකදීම right මේ කියන්නේ වෙන කේස් එකක් අර කලින් කේස් එකේදී වුණේ the learn jacketing case as per the මේ කේස් එකේමයි Supreme Court එක මොකද කරේ justify කරා vacation of post කියන එක justify කරා. හරි. Now subtopic, ladies and gentlemen, take your note, conducting the disciplinary inquiry and the punishment. Conducting, subtopic, conducting the disciplinary inquiry and the punishment. So, we will go for a break from now onwards until now 9:16, now up to 9:30, we will go for a break. Okay? Right. Okay. I'm going to start subtopic conducting the disciplinary inquiry and the punishment. So, these are the, first of all, we need to understand what are the importance of disciplinary inquiry. Why disciplinary inquiry is needed? Because it can establish the bona fides of the employer, right? And then it helps, just 1 second. It helps to protect, right? It protect, what do you call, the natural justice. Natural justice. You have learned this, natural justice. Here, the both sides, no one can hear his or own case. This is the two elements of the natural justice. Bona fides. සත්භාවයෙන්ද මේ වැඩේ කළේ කියලා දැනගන්න. Right. It fulfills the mandatory requirement of the collective agreements internal discipline code, if any. තියෙනවා නම්. Also, it is a fact-finding mission. So therefore, because of this, the holding disciplinary inquiry is important. Then under that one subtopic, importance of the disciplinary inquiry, and you take this note. ඔයගොල්ලෝ මේක ලියාගන්න. Finish? Shall I move?
Okay, sir.
Right. Next. Important facts in relation to the disciplinary inquiry. Important fact. One is, relevant statutory. First of all, we need to understand what are the relevant statutory provisions. And the statutory provisions must be followed. For instance, under the Termination Act, the reasons for the disciplinary termination must be informed to the employee before the expiry of the second working day after the date of such termination. This is not valid at present. This is not valid at present because we have court cases. Not valid at present. You don't need to write this, right? Not valid at present. Sorry, valid is spelling mistake. Right. Valid at present. This is not valid at present. Under the Gratuity Act, the employee is allowed to forfeit gratuity of the employee who has caused the damage to him. Under the Gratuity Act, up to 30% surcharge of the gratuity will have to be paid by the employer if do not pay within the 30 days of the termination. So we don't need to write this one. The disciplinary procedure. Next one. The subtopic next disciplinary procedure. This is the disciplinary procedure. The necessary steps that should be followed by the employer. Right. So how do we get this? This is from a court decision. Ceylon Estate Staff Union versus the superintendent. You don't need to write this one, but this procedure, the necessary steps that should be followed by the employer. One is recording of a statement of a complaint, witness, and accused. Preliminary investigation. This is what we call preliminary investigation. The so-called letters. නිදහස්ට කරුණු වහලා ලිපියක් දෙන්න, ලියුමක් දෙන්න ඕන. The charge sheet. ඊට පස්සේ charge sheet එක දෙන්න ඕන. And then holding an inquiry properly, proper inquiry, and without delay. Communicate on the decision within 2 days if there is a termination. Termination එකක් තියෙනවා නම් 2 days communicating the decision, but this 2 days is not actually required, but it has to be communicated. Okay. So let me, instead of taking note with this, in this regard, we will move to next slide. This is important. This say, very precise steps. Disciplinary procedure. Subtopic, disciplinary procedure steps. Preliminary investigation or collecting the evidence. Issuing the so-called letter. Explanation by the employee. Suspension or interdiction, if any, if required. Serving the charge sheet. Conducting the disciplinary inquiry and the report. And then the punishment. This is the exact procedure of steps with regard to disciplinary procedure. You take your note. Disciplinary procedure, steps. There are 7 steps. I hope you have finished, no? Is it? Have you done? Is it finished?
Yes, sir. Finish.
Right. Then the first step, preliminary investigation and collecting the evidence. Preliminary investigation and collecting the evidence. Step number 1, right? Preliminary investigation and collecting the evidence. Actually, preliminary investigation is conducted in order to collect the evidence. Saksi hoyagan. Okay, this must be based on the first information and the types of misconduct. This must be based, preliminary investigation should be based on the first information and the types of misconduct. For instance, if the misconduct is related to drunkenness, the relevant steps should be taken to prove the drunkenness of the employee. For example, if the information is revealed to the sexual harassment, another case, the statement of eyewitness must be recorded. Further, if the CCTV camera was in operation, the recordings must be protected, right? So all these things should be, right, protected because, you know, these are very, very important information, right? drunkenness එකෙත් මම කිව්වා ඩොක්ටර් කෙනෙක් ගාවට යන්න ඕන පොලිසිය පැමිණිල්ලක් දාන්න ඕන දේ දේවල් කරලා තියෙනවද කියලා හොයලා බලන්න. So take your note, preliminary investigation and collective evidence. This must be based on the first information and the types of misconduct. For instance, if the misconduct is revealed related to the drunkenness, the relevant steps should be taken to prove the drunkenness of the employee. Right? Okay. Likewise, you know, you take your own notes. I don't need to read it. Let me know. Once you finish, let me know. Only few is remaining. I don't know anyway. It's up to them now. Is it finished? Not yet.
Finish, sir.
Right. This is, you don't need to write this one. The second step, summary termination is accepted. These are also, with regard to summary termination, imposing punishment summarily. These are also, yes, preliminary investigation. This is something, had been reported. Important steps of the preliminary investigation. So we, what we have written, this is the, no, where was it? Preliminary, sorry. This one, preliminary investigation. So under preliminary investigation, ladies and gentlemen, next one is, after that, right, you have to take this note. Important steps. What are the important steps with regard to, it has been, already there, right? We discussed this one, right? And then number 2, what is the number 2? Is a showcase letter, show-cause letter, sorry. What is the second step? Tell me.
This one.
Issuing a show cause letter.
Number 2, next. Issuing a show-cause letter. Issuing a show-cause letter. Let me do it myself. Issuing a show-cause letter. So, show-cause letter, take your note, I will read it per para. Show-cause letter contains, show-cause letter contains the following. Show-cause letter should contain, show-cause letter should contain the followings. One other, the letter must be in the language that the employee can understand, or translation must be attached. If you will be given a show-cause letter, if your employer gives you a show-cause letter, that letter, you should be able to read it. The language that you know, it should be issued in the language that you know, that you can read. Otherwise, the translation, say for example, if you can't understand English, the show-cause letter issued in English, so then accompanying translation should be there, or translation should be attached in Sinhala. And mentioning the date and time approximate of the incident misconduct. වැරද්ද misconduct එක. ඒ කියන්නේ විසමාචාරය සිදුවෙච්චි දල වශයෙන් දිනය වෙලාව. Describing the misconduct විසමාචාරය විස්තර කරන්න ඕන. Allegation correctly. That means the employee should be able to answer it properly by not misdistrusting himself. If there is a disciplinary code or collective agreement which employees bind, the relevant section and the names must be mentioned. If anything, is there, the code of conduct or whatever it is, the disciplinary code in the company. And if you have violated any clause, that clause has to be mentioned. Mentioning the time and limit within which a written explanation should be tendered, generally 7 working days, and presumption that she has no explanation if he fails to submit the answer within the given time period will be made against the employee. Time එක මේ සෝකෝස් ලෙටර් එකට උත්තර දෙන්න එපා. ඒ උත්තර දෙන්න ඕනේ කොයි කවදට කලින්ද කියලා දැනුම් දෙන්න ඕනේ. ඒකේ තියෙන්න ඕනේ. සාමාන්‍ය දින 7ක් working days. එහෙම තමයි දෙන්නේ. ඒ දින 7 තුල එයා උත්තරයක් දුන්නේ නැත්නම් එයාට උත්තර දෙන්න දෙයක් නැහැ කියලා සලකලා කටයුතු කරන්න ඕනේ. Mentioning to whom the answer must be tendered. Answer එක උත්තරේ යවන්න ඕන කාටද කියලා දැනුම් දෙන්න ඕනේ. Mentioning whether the service is suspended or not. ඔබගේ සේවය අවසන් කරනවද නැද්ද මේ අනුව කියලා දැනුම් දෙන්නත් ඕනේ. So ලියා ගන්න මේ. Number 1. What I said was the so-called letter should contain the following. එහෙම නෙලියුවේ. දැන් following ටික ලියා ගන්න. The letter must be කියන තැන ඉඳලා other if any. When you finish, let me know. Is it finished? ඉවරද?
Yes, sir.
You know, this topic is very, very important. I don't know why, because maybe electricity problem and but okay. So of course later these are some of the code decisions, right? We don't need to write this, and so of course later continuation again. Code decisions, right? Number 3, explanation by the employee. Number 3, explanation by the employee. Explanation by the employee. Right? Ladies and gentlemen, if the explanation is accepted by the employee, if the explanation is accepted by the employee, if the explanation is accepted by the employer, explanation by the employee, no, if the explanation is accepted by the employer, not employee, employer, imposing suitable punishment. එයා ඒක පිළිගන්නවා නම් එයාට පුළුවන් if the explanation is accepted by the employer, suitable punishment එකක් දෙන්න පුළුවන්. If the charges are denied by the employee, charge sheet එක එයාට දෙන charge එක එයා deny කරනවා නම් by the employee and the explanation is not accepted by the employer, then if there is a strong prima facie case, ඒ කියන්නේ prima facie case කියන්නේ මේ බැලූ බැල්මට පෙනෙන සාක්ෂි case against the employee, such as vacating the quarters, employee such vacating the quarters කියන්නේ මේ අපි මේ උදාහරණ කලින් දීපු වගේන් ගත්තේ. Suitable punishment may be imposed or the charge sheet may be issued and formal inquiry will be fixed and then commencing inquiry. Okay, so this is the third step. Okay, third one, explanation by the employee, right? Medically agar You know, you need to understand prima facie case means, just at the first instance, it can be, අපි සිංහලෙන් කියනවා මේ බැලූ බැල්මටම හඳුන ගන්න පුළුවන්. එයා වැරද්දක් කරා කියලා. ඒක තමයි prima facie case කියන්නේ. ඒ කියන්නේ සාක්ෂි තියෙනවා හඳුන ගන්න බැලූ බැල්මටම. Shall I move?
Okay, sir.
Okay. Suspension, interdiction, it's up to the employee. We have court cases. I'm not going to discuss these things. Steps are important. Right. Next, number 4. Holding a formal disciplinary inquiry. Holding a formal disciplinary inquiry. There are important things that you need to understand. 1, avoiding leading hearsay evidence. නිකන් අර බැලු බැල්මට පේනන නෙමෙයි in detail යන්න ඕන. මේක court decision එකක්. ඒ නිසා අපි ලියන්න නැතුව යමු. Right? Formal charge sheet. This is the one. You need to take note. Number 4, formal charge sheet. Contents. මොනවාද මේ formal charge sheet එක ඇතුළත් වෙන්න ඕනේ? Mentioning the date and the time, approximate of the incident or misconduct. charge sheet එක දෙනකොට මේවා ඇතුළත් වෙන්න ඕන. කවද්ද මේ වැරද්ද misconduct එක මිසමාචාරය කළේ කියන එක. දිනය සහ වේලාව. Describing the misconduct allegation correctly. ඒ කියන්නේ මොකද්ද කරපු වැරද්ද කියලා පැහැදිලි කරන්න ඕන. Right? Giving the date, time and place of the inquiry is to be held. Inquiry එක පැවැත්වන දිනය, time එක, වේලාව, place එක දැනුම් දෙන්න ඕන. Providing the details of the witness and documents or other materials that are to be used against him to prove the charges. කියන්නේ අදාළ document, සාක්ෂි සියල්ල රැස් කර ගන්න ඕනේ මේ formal මේ කියන්නේ charge sheet එක දෙන වෙලාව වෙනකොට. හරි. Providing the details. ඒවා details දෙන්න ඕනේ. Mentioning whether she or he is permitted to retain a depending officer or lawyer. මේ formal charge sheet එකක් දෙන වෙලාවේ inquiry එකක් අනිවාර්යෙන් තියෙනවා. එතකොට inquiry එක එයා වෙනුවෙන් depending officer කෙනෙකුට ඉන්න අවස්ථාව දෙන්න පුළුවන්. ඒකත් කියන්න ඕනේ. Revealing the name of the inquiring officer. inquiring officer කවුද කියලා කියන්නත් ඕනේ. formal charge sheet එක දෙනකොට charge sheet එක දුන්නා ඒ අනුව inquiry එක තියෙනවා මෙන්න මේ දේවල් fulfill වෙන්න ඕනේ කියලා. Right? So, ladies and gentlemen, you take your own notes. මේ ටික ඔයගොල්ලෝම ලියා ගන්න. ඊට පස්සේ මේක පස්සේ බොහෝ වෙලාවට මම මේක නවත්තනවා මොකද once you finish this, you let me know. Have you finished? Did you? Hello?
Yes, sir, finish.
Okay, so therefore, only, except me, only 3 participants. So, so shall we stop at this point? What do you think? Do you want me to continue? Or we have another 25 minutes. It's up to you. Shall we continue? Or shall we wind up?
Shall we wind up, sir?
Okay. So then we have to start from the next slide. This is formal charge sheet and then holding disciplinary, holding formal, where is that? Holding, yes, formal disciplinary inquiry. So some, slide has, it should come here. Right, okay. We have to start next day from holding a formal disciplinary inquiry, right? Next step. From slide number, we have to start from slide number 85. So please remind me. So thank you very much and good night for everyone.
Good night, sir.
Good night.
Good night, sir.
Okay.